So good morning again. I'm Katie Doherty, the President and CEO of the Kennebec Valley Chamber. Thanks for joining us for our weekly Chamber Connect sponsored by Central Maine Power. Before we get started, I just wanted to mention we will be recording this presentation so you can use it as a reference. We will be emailing it out later. Put your questions in the chat box. We will have time for Q&A in the end, and we'll have a good amount of time for that. If you do have questions, please feel free to put them whenever they pop up, and we'll get to them. Today's webinar, we are joined by Rebecca to discuss a guide to COVID-19 related return to work issues. Rebecca is an associate in Eaton Peabody's Employment and Labor Practice Group based in Bangor. Prior to joining Eaton Peabody, Rebecca graduated magna cum laude from University of Maine School of Law in 2018, where she was the online editor of the Ocean and Coastal Law Journal and president of the Student Bar Association. So thank you for joining us this morning, Rebecca. And at this point, I will turn it over to you. So I will stop sharing my screen and let you share over your presentation.
Okay, great. Hi, everyone. Thanks for joining us today. I'm gonna hope that this works and put up my presentation. Can we see that, Katie?
Yes, it works great.
All right, great. So we're talking about getting back to business today. I know that's something that a lot of folks, a lot of businesses have had a lot of questions about, are really concerned with following the letter of the law, and there's a lot of ongoing changing laws, so it's a tough thing to do right now. Depending on how long you've been open for, or if you're still in the process of reopening, that might change what type of information you're looking for. And if you do have specific questions, I do encourage you to reach out personally to me or to any of our other employment and labor attorneys at Eaton Peabody, so we can answer your specific questions, as I can't necessarily provide you with specific legal advice today, but if you do have specific questions, do reach out to us and we'd be more than happy to take a look at that for you. So just to get started here, things to be aware of. So in Maine, we have a number of reopening checklists. There is a general checklist as well as specific industry checklists. So depending on what your business is, you're going to want to make sure that you're following everything that is in that checklist for your type of business. The other thing you want to make sure that we are aware of are the CDC guidance on cleaning and safety procedures. That's going to be really important to keep an eye on for making sure that your employees and your customers all feel safe and reassured that they are entering a safe environment, as well as making sure that you're in compliance with any state guidelines and laws as well. OSHA is categorizing businesses under different levels of risk right now. There's a very high exposure risk, a high exposure risk, a medium, and a lower risk level for different types of businesses. Most American workers are going to fall under that medium or low risk level. And that's a good thing to know, because that's going to reassure your employees when they're coming back to work that they're not in a high risk environment. The very high risk environments rather, are individuals who are working directly with positive testing COVID patients. So that's going to be your healthcare workers like doctors and nurses, EMTs, et cetera. And healthcare laboratories, folks who are testing for COVID, morgue workers, things like that. So anyone who is working directly with a person who has tested positive is going to be a very high risk category. A high exposure risk category is going to be healthcare delivery staff, support staff, folks who aren't necessarily working directly with a COVID positive patient, but may have some tangential access to them, medical transport workers, things like that. Whereas a medium exposure risk is going to be a lot more common. That's going to be anyone who's working at a business where maybe they can't maintain 6-foot distancing all the time. So that could be high population environments, areas where there's ongoing community transmission. So you're going to want to pay attention to your particular town and city and see sort of what the community transmission rates are, if there are any. And that's going to determine if you go from low to medium risk, depending on sort of your interaction with the public and how likely you are to be exposed or have your employees or your customers exposed. Low risk is going to be most of your office jobs where folks are not necessarily interacting with each other. They're in their own private space, minimal contact with other individuals, able to maintain that 6-foot distancing at all times. And that's going to be, like I said, a lot of office jobs, a lot of your day-to-day businesses where you don't have a high volume of traffic coming through on a regular basis. So we do want to make sure that we are communicating clearly what our expectations are with our employees and with our customers. And we're going to follow up with, in a little bit, with some information about the Families First Coronavirus Relief Act, which is the FFCRA, which is going to mandate certain requirements for employee leave, mask requirements. And I know the big topic that a lot of people want to know about is unemployment, and getting employees back to work, and unemployment reporting if folks don't come back to work. So these are all important things that we're going to cover today. I want to start a little bit with the CDC guidance. A lot of that is available online, and you can do a quick Google search, find out what they're recommending, but we can also answer those questions for you. It's going to be a lot of regularly checking for cleaning and safety measures, ensuring that those measures are being followed and that they are being applied universally throughout your business, making sure that we have access to hand sanitizer, hand soap in the bathrooms, cleaning regularly, providing easily accessible trash receptacles, preferably ones that are no touch. We're also going to want to make sure that we have established policies at all of our businesses. So we're going to try, the CDC is recommending that we be flexible with employees. If they can work from home, that is encouraged. If they can't, then obviously we need to consider alternatives there, especially for retail establishments, restaurants. Obviously, a lot of your employees aren't going to be able to work from home in order to maintain those businesses. So trying to figure out what those alternatives are and what's best for your specific business. In terms of an office environment, if folks are coming into the office, we want to make sure that they aren't sharing phones, they aren't sharing equipment, computer, keyboards, mouses, or mice, I guess. And discourage employees from coming in if they have any symptoms. I realize that we want our employees to come in, but it's really key that we make sure that they understand that they are not to come in if they have any symptoms related to the coronavirus or to COVID-19. We want to make sure that employees are self-monitoring, making sure that they report if they have any exposure to a positive case and need to quarantine. And make sure that we're respecting those employees' privacy and their rights if we do find out that information. So CDC has online, like I said, a lot of materials. They have these great worksheets sort of that go through what a lot of their guidance is for small businesses that are reopening. A lot of the things on this poster I just mentioned, like ensuring that you have flexible work policies if people can work from home, making sure you're establishing that 6-foot distance, making sure that we are preparing for if we have an outbreak at work, everything like that. We want to make sure that we are ready to go and prepared and that we have a point person at all of our businesses. So I just wanted to include this visual, but like I said, you can find this online. You can go to cdc.gov/coronavirus. They do have a lot of resources on there for what your practices should be as you reopen and as you run your business for the time being. So the other thing I want to talk about here is the Families First Coronavirus Response Act. I think I said Relief Act earlier, sorry. This is the FFCRA. So if I say FFCRA, this is what I'm referring to. It was enacted on March 18th, and it includes a number of provisions which require certain paid leave benefits for all businesses with fewer than 500 employees. There are a couple exceptions to that, and I will get to that. So the FFCRA includes both an Emergency Paid Sick Leave Act as well as an Emergency FML, Expanded FMLA Act. So any employer with fewer than 500 employees and all government employers are required to provide all employees, and that means full and part-time employees, with 2 weeks of sick leave for either a state or federal mandated quarantine. If an employee has been advised by a healthcare provider to quarantine due to COVID-19, or if an employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Now, I want to point out here that the keys are that it's in a federal, state, or local order to quarantine, a healthcare provider ordering the quarantine, or they are seeking a medical diagnosis. Those are the only reasons you have to provide sick leave. If it's an employee's fear that they want to stay home and quarantine, that doesn't count. If it's an employee who traveled to New Hampshire, which no longer requires a quarantine when they return, it is not required. However, if an employee leaves the state to a state that is not part of the exception for states that for travel that requires quarantine upon entering Maine, you are going to have to pay that 2 weeks of sick leave because the employee is now being mandated by the state to quarantine. And this is a contentious issue that a lot of employers have not been happy about. That does mean that if your employee goes on vacation out of state or out of the country voluntarily for no other reason than that they wanted to, and then they come back, you still are going to have to require them to quarantine for 2 weeks or until they get a negative COVID-19 test before they can come back to work. And that means you are going to have to pay up to that 2 weeks of paid leave for that quarantine period. We have confirmed this with the USDOL. It is how they are enforcing this law. So you can ask the employee to get a negative test result and come back to work. You can also ask the employee to telework and work from home, but they will have to quarantine if they leave the state and return unless they are going to one of the states that is an exception to the rule. And that is only because it is a state mandated quarantine. If the executive order is changed so that it is no longer a state mandated quarantine, then you won't have to provide the paid leave anymore. Also, if they travel for essential work-related business and return, then they won't have to pay the quarantine because there is an exception in the executive order for essential business travel. And again, if an employee is advised by a healthcare provider or they are seeking a medical diagnosis, you will have to pay that sick leave. If an employee is requesting leave to care for an individual, such as a son or daughter or a family member, or if they are experiencing a substantially similar condition as specified by the Secretary of Health and Human Services, then we have to pay sick leave at 2/3 their rate of pay for up to 2 weeks. So full-time employees are going to be entitled to 80 hours of pay. Part-time employees are entitled to the average number of hours that they would typically work in a 2-week period. If we have part-time employees who have been working for less than 6 months, there's a different formula that you can use to figure out how many hours they are entitled to. But essentially, it's going to be about 2 weeks of their normal work schedule that they are entitled to for this paid sick leave. And this is the only 2 weeks that they are going to be entitled to. It's in addition to any paid time off you already offer. And it is going to be subject to a payroll tax credit, subject to a cap. And I do have a chart that will show you sort of the difference in how much is paid out for different types of leave and what the cap is for each of those types of leave. It is important to note, though, that the first 3 reasons require full rate of pay. The second 3 reasons that I listed are required 2/3 the rate of pay, and it's a total of 2 weeks. So once they use their 2 weeks, they don't get another 2 weeks. So if they keep going on vacation and coming back, they're only going to get paid for the first 2 weeks of quarantine. They're not going to get it the next time they go on vacation or the next time they have to leave the state and come back. So this is the chart I was mentioning. If you see here, these first 3 reasons, like I said, are going to be at your regular rate of pay. They are capped at $511 per day. The third, fourth, and fifth, I'm sorry, the third, fifth, the fourth, fifth, and sixth reasons are going to be at 2/3 the rate of pay, and they are capped at $200 per day. Now that cap applies to how much you're going to be eligible for on the payroll tax credit. So you can pay their full rate of pay or their 2/3 rate of pay beyond that cap, but you're only going to be entitled to a payroll tax credit for the capped amounts. So that's important to remember, and there is an opportunity for employees, if they prefer to have their full rate of pay, to use their regular PTO rather than using this paid sick leave, but that's something that you would have to come to an agreement with your employee about. Like I said, this is in addition to whatever paid sick leave is already offered, and the sick time mandated under this law will not carry over. So this is 2 weeks for the period of time that the law is enacted for, and it's not something that they get to keep once the pandemic has ended, which will hopefully be someday in a near future. Like I said, there's also the expanded FMLA provisions in the law. So this is going to require employers with 500 or fewer employees to provide 2 weeks of unpaid leave and 10 weeks of paid leave of emergency FMLA. And this applies to employers who don't normally have to follow FMLA, who aren't usually eligible, because it applies to all employers with fewer than 500 employees. The employee must have been employed for at least 30 days, and as opposed to the sick leave provision where it applies to all employees. For the FMLA leave, the employee has to have been employed for at least 30 days. If they've already exhausted their FMLA leave for the year, they will not be eligible. And you don't have to do the normal FMLA paperwork. However, you should require certain limited documentation in order to make sure that you've got what you need in order to get your IRS tax credit for the payroll tax credit. Like I mentioned, there is a payroll tax credit, and that is going to allow you to get dollar for dollar offsets against your payroll taxes for all the money that is paid out under the FFCRA paid leave requirements. So as much as this can be discouraging for employers to realize that they have to offer this leave, you will get a dollar for dollar tax credit on any leave that is paid out for these reasons. I should note that the FMLA leave is only for care of a son or daughter whose child care is no longer available due to COVID-related reasons. You are limited in what you are allowed to ask employees about this. You cannot ask them for alternative childcare arrangements per USDOL. And we do need to make sure that we are allowing employees to take this leave if they are requesting it, but we need to make sure we are documenting that they have certified that their normal childcare provider is not available due to a COVID-related reason. It has to be a COVID-related reason, and that the employees do not have another parent or guardian at home who could be caring for the child. That's pretty much all we can ask, and we need to have that certified in writing, as well as the child's name and the reason why the provider is no longer available. As I mentioned, the first 2 weeks are going to be unpaid for the FMLA leave. That can be substituted with the 2 weeks of paid sick leave that is available for the same reason. If they've already used their 2 weeks of sick leave for quarantine or to seek advice from a healthcare provider, then they'll have exhausted that leave, and that first 2 weeks can be unpaid, or they can substitute their accrued pay time off if it's an agreement that they come to with you as the employer. Okay. So there is a small business exemption, and this applies only to the FMLA related leave. You still have to provide the paid sick leave, but if a business has fewer than 50 employees, you can claim an exemption as a small business for any of the following 3 reasons, which I have listed here. And it's essentially going to say that it's impractical for you to maintain the viability of your business if you provide this leave. So it could be because you can't financially afford to provide this leave, you would have to cease operations if you provided this leave. You don't have sufficient workers available to cover this employee's position, or there would be a substantial risk to the financial health and operation of your business. If you determine that you think you meet this the eligibility for this exemption as a small business, you should document that and keep that filed. They're not asking, DOL is not asking that folks submit their exemption requests. They're just saying to use your discretion and maintain paperwork and records that show that you are exempt from this FMLA leave. And again, this is only for the child care related leave. It is not for the paid sick leave provisions that are unrelated to child care. There's also a healthcare provider exemption. I don't know if we have any healthcare businesses with us today, but for healthcare providers, there is an exemption that allows you to be exempted from paid sick leave and FMLA leave for certain employees who are healthcare providers or emergency responders. However, DOL has requested that employers use this judiciously to avoid the risk of spreading the virus. There's more information on the slide here, but that is another exemption that does exist. There's also an employee rights poster that all employers with fewer than 500 employees are required to post throughout your business. If you haven't already posted this poster where your employees can see it, it is available online from the USDOL, and you should post this poster wherever employees can see it. So if you have a break room, common areas, or somewhere else that you post your usual DOL posters, put this up with those and make sure that employees know that they do have these rights available to them. If your employees are all working from home, it is permissible to send this out via email. DOL has not clarified if this is required for businesses who are exempt or who are seeking an exemption. So to be on the safe side, even if you're going to seek an exemption, I would post this up in your business for your employees to see. So COVID-19 testing. This is another questionable topic here, and the EEOC has clarified that employers may test employees for COVID-19 before allowing them into the workplace. This is, again, something you might want to use judiciously depending on what your circumstances are, but if you have a high-risk environment and you want to make sure employees are being tested before they enter the workplace, you can. You can also require testing if someone, again, leaves and returns to the state before they come back into work. Employers may not require employees to get antibody tests. That has been determined to be a violation, so do not ask your employees to get antibody tests or to submit any antibody test results. Make sure that if you are doing testing or any type of medical related employee testing for any reason that is allowed, make sure that you are maintaining those records privately, confidentially, and that you are maintaining employee confidentiality at all times. So mask enforcement. This is another contentious area of the law. And we've had a few executive orders in the state that address this issue. So in April, it was mandated that individuals must wear a face covering in any public space where physical distancing is difficult to maintain. And private employers were given the option of allowing or giving the option of mandating masks in their private business space. But you must allow an employee to wear a mask if they request one. The May executive order required businesses to post visible signs identifying that customers entering the business must wear a mask. So make sure if you are a public-facing business, you do have that sign up. And the most recent executive order just this month mandates that businesses must actually require the face coverings in large capacity retail stores, restaurants, outdoor bars, or tasting rooms. And this is going to be limited to certain counties where it's been determined that there's either a high population or likelihood of high amounts of tourism, as well as a few larger cities. So it's going to be Hancock County, Waller County, Knox County, Lincoln County, Sagadahoc County, Cumberland County, and York County, as well as Bangor, Brewer, Lewiston, Auburn, and Augusta. So if your business is located in any of these areas, you do need to mandate that folks are wearing face coverings when they enter your business if you are one of these businesses that this applies to. You need to be cautious of ADA accommodation requests. With employees, you have a little more flexibility to find out what kind of accommodations they might need. With customers or the public, it's more limited. If they say that they can't wear a mask because of an ADA related disability, you do have to accommodate that and can ask a lot of follow-up questions. That said, accommodations are going to vary depending on what your business is and what type of services you are offering. If you're not sure how to accommodate folks who can't wear a mask, I would recommend talking to your attorney. Feel free to reach out to us and we can discuss what your business arrangements look like and how you might be able to accommodate requests to not wear a mask. I should note that there are enforcement mechanisms in this executive order. A violation may be construed to be a violation of your business license, and there is the ability for licensing bodies to revoke or suspend licenses and permits, so you want to be careful. There's also a reporting form for any alleged violations online, so folks can report you if they think that you are not following the letter of the law. So again, we want to be really cautious of this and make sure that we don't lose any of our licenses or permits because we weren't following this order. So just be really careful about that and do the best you can. It's unfortunately one of those areas where there's not a great answer on how you're supposed to enforce this, but just do the best you can to try and follow the law. Generally speaking, we advise that if you're doing the best you can and you're trying really hard to follow the law, you're probably going to be okay because you're trying within reason. And I know this is one of the biggest topics that everyone wants to talk about, and that is unemployment. So everyone seems concerned with how to get your employees back from furlough or layoff. I understand the concern there. The reality is that a lot of folks are making more money on unemployment than they might at their regular jobs, but that said, that doesn't mean they don't want to have a job when their unemployment expires. Normally, unemployment is available for 26 weeks. It has been extended by 13 weeks as of July 1st, and that's going to depend on when the folks started unemployment and what their benefits are that are available. The $600 a week additional benefit is set to expire on July 31st. So folks who are receiving that benefit as of right now will not receive the benefit after July 31st. However, that may be extended or the amount may change. It could be less, it could be more, it could be the same. We're not really sure how that's going to turn out. There is a bill that has been passed in Congress but has not gone through the Senate yet, as far as I'm aware. I think that it's important to remember that empathy and reassurance are going to go a long way. Remember that your employees are nervous. It's not just about the unemployment money. They're scared of going back to work. They've been told that this pandemic is deadly and they are afraid to be out in public. Reassuring them that you are following all mandated safety precautions and measures is going to help a lot to get them back to work. You do not have to hold their job indefinitely for them. However, there might be employees that request additional leave or time off or flexible schedules or some other accommodation if it's related to an ADA disability. So we want to be on the lookout for ADA related requests. If an employee is just saying, I don't want to come back because I don't like coming to work, that's not going to be an ADA request. However, if an employee is saying, I am a high risk person because I have a certain medical condition, then they might be making an ADA protected request for either additional leave or some other accommodation. Same thing for folks who might suffer from severe anxiety or OCD. These are things that we want to look out for. And if the employee is making a request related to a disability accommodation, that would be a good time to talk to your attorney to figure out what the reasonable accommodations that won't harm your business could be. Again, work from home if possible. For a lot of businesses, that's going to solve a lot of your problems. If folks can just work from home, they'll probably be pretty happy. If it's not possible, then obviously we need to consider other options. And if you do have folks who just straight up refuse to return to work, the DOL is investigating unemployment fraud. So folks who are seeking unemployment or getting unemployment when they should not be. For instance, if they had a job offer and they refused to go back for a non-COVID related reason, they are not entitled to unemployment benefits anymore. So DOL has, and this is the main DOL, does have a form available online now for employers to go on and submit information if an employee has been offered a job and refused to return to work, and if that employee is receiving unemployment benefits. So if you have employees who did not submit an ADA request for an accommodation, who just refused to come back to work, who's been on unemployment, DOL is requesting that you go and fill out that form and report that the employee was offered work and that they refused to return. Now, ultimately, the decision of whether that employee is still entitled to unemployment benefits is up to the Department of Labor. It is not up to us. So just report honestly and accurately as much as you can. Try not to bring any personal feelings into your reports. Just report honestly and accurately what was offered for work and who refused to come back. And if it's determined that their refusal is not related to COVID-19, then theoretically they should lose their unemployment benefits, which again should encourage folks to go back to work, because it's not a great situation to be in, to be out of a job and out of unemployment benefits. So, you know, again, communicate clearly with your employees what your expectations are, when you expect them to come back to work, what procedures are going to be in place to ensure that they are safe, and you know, that if they refuse to come back to work, you will have to report that to DOL per the request of the Department of Labor. If employees are on unemployment due to COVID-19, your experience rating will not be charged as long as the reason that they are on unemployment is related to the pandemic. So, let's see. So make sure I covered everything there. Okay. So for folks who have taken out a PPP loan, I'm not going to get into the details of the PPP loans. It's not my area of expertise. However, I do want to mention a little bit of update regarding loan forgiveness and rehiring provisions. The PPP loans required that you reemploy folks before June 30th of 2020. Essentially eliminating any reduction in employment, salary, or wages in order to get a full loan forgiveness on your PPP loan. That date has come and gone. They have extended the safe harbor with the PPP Flexibility Act. So you now have until December 31st to return your workforce back to normal. And the act has also allowed for loan forgiveness not to be affected if the decline in full-time employee counts is based on something that's essentially not your fault. So if you have an inability to rehire individuals because if an inability to rehire individuals who were employees, or an inability to hire similarly qualified employees before December 31st, especially if it is related to anything regarding the pandemic, or if employees are refusing to come back to work, if it's not possible to find similar qualified employees, if you can say in good faith that these things were sort of out of your control, or you had a decline in business that doesn't allow you to rehire to the same level, then there is still that extended safe harbor. And again, this is not, the PPP loan is not an area of my expertise, but I do have contact information for another attorney at the firm if you do have specific questions related to PPP loans, the forgiveness, or any other parts of the PPP loan process. And so I will have that information for you. So like I said, I do have that information here. The contact would be Jack Bjorn. He is based in our Portland office, and he is the one who is covering all the PPP loan information. If you have additional questions about employment law, labor law, or any of the FFCRA provisions on employment, you can contact anyone in our employment practice group, including myself, Attorney Matt Rains, or Attorney Sarah Newell. Any of us would be happy to answer your questions and help you figure out sort of how to navigate this unprecedented time. So that's all I have for you today, and I'm open to any questions that folks may have.
Perfect. Thank you, Rebecca. So feel free to put some any questions you have in the chat box. I did get a couple questions sent ahead of time. Let's see. What happens if my employee doesn't want to return to work because they do not feel safe? Can I fire them? Can I let them go? Or because it's COVID related, can you offer some guidance on that?
So that's, again, it's going to be fact dependent. It's really going to depend. If it's just a general concern or fear of the pandemic, then you do not have to hold their position for them. You can let them go. You can lay them off, or fire them, or terminate the employment. That said, if they are saying that they don't want to return because they are at a high risk due to a certain disability or illness, then we might need to consider ADA accommodation. So you want to make sure that you are not firing anyone in retaliation or because they are unable to return to work due to a protected category such as an ADA disability. Or for instance, if an employee is saying that they can't come back to work because they need to take leave under one of the new FFCRA categories, and it's going to be for a temporary period. If you were to deny their request to take that leave instead of coming back to work, then you could be in trouble for some retaliation under the protection of those laws. So it's really going to be fact dependent on why they don't want to come back to work. And again, that's something that you might want to discuss with your attorney.
Perfect. Another question that was sent is, what are my legal rights when it comes to making my employees wear masks and they refuse?
So again, it depends on if there's an ADA accommodation required. But you, and again, it depends on if you are a private employer or a public employer, in the sense, not in the sense of being a publicly funded employer, but being open to the public. If you are open to the public, you're going to have more strict requirements. Your employees are going to be required to wear a mask under the law because they are public facing, unless they have an ADA required accommodation request. As a private employer, you can enforce a mask mandate, and again, it's going to depend on why they are saying that they can't wear a mask. There are some arguments that COVID-19 is a direct threat, meaning that not wearing a mask could pose a risk to oneself or others. So there's some arguments to be made there. However, it's sort of an issue of debate. And I would say that if you have employees who are refusing to wear a mask and they have not made an ADA accommodation request not to wear a mask, that you can enforce that and require them to wear a mask. But again, it's going to be fact dependent, and unfortunately this is always going to be my answer. You might want to talk to your attorney because it's really going to depend on the specifics of that situation.
Question in the chat box is, what if an employee's household member needs to quarantine? Does that employee qualify for emergency sick leave expanded by FMLA?
So it's not going to be covered by the FMLA. The FMLA, expanded FMLA leave is only to care for a child whose daycare or place of care or school is no longer available due to COVID. It might require the employee to quarantine under these paid sick leave provisions. Now, this is only going to happen if there is a medical provider who is saying that their exposure requires them to quarantine, or if they are also showing symptoms and seeking testing, or if they've been exposed so they are seeking testing. In those cases, you might have to pay the paid sick leave for the 2 weeks. If they have been exposed and have no symptoms and no one's told them that they have to quarantine and they just want to, then you do not have to pay that paid sick leave. If it's just their voluntary choice to stay home or to self-isolate, then you do not have to pay that paid sick leave. If it's mandated by their state, local, or local government, if it's mandated by a healthcare provider, then you would. It's also important to remember that if someone has been exposed, you might not want them coming into your workplace right away. So you can ask that person to get tested before they return to work.
So one more question that got sent is, what if I ask my employees to return to work, but they do not want to and want to continue working from home? Do I have to allow that, or can I make them come to work?
Again, that's going to be fact dependent. I'm sorry, I sound like a broken record here. It depends on why they're requesting to work from home. It depends on what their job is. It depends on what your business is, because there may be an accommodation request there, and it may be something that you have to accommodate temporarily, but not forever. It may be something where they are not able to perform the functions of their job fully from home, and now that it is safe to go back to work, you don't have to require that accommodation. But it may be a situation where they can fully perform the functions of their job from home, and you don't really need them to come back into the office, and they do have a reason to need to stay home, so you might have to accommodate that. It's really going to be fact dependent on what that employee situation is, what their job is, and what you need them to do. And again, the reason why they are asking to stay home. And again, we want to be careful about what we ask when we ask them, why they need to stay home or work from home. So for instance, if an employee does have children whose day camp or childcare provider is not available, so they're asking to stay at working from home in order to provide care for their child under the, or they're asking for intermittent work schedules so that they can take care of their child, we might need to consider that under the Expanded Family Medical Leave Act.
Perfect. Another question. I just want to apologize too if anybody hears noises there. Somebody's here fixing our AC in the office, so I apologize if any random noises happen. Another question is, if employer suggested or required all employees to get tested once one employee disclosed a positive test, the testing occurred on a holiday, does employer over double pay? Can it add substitute vacation days? What are employers' options? Assume A, employees volunteered, B, assume employees felt they were obligated.
I'm sorry, I might need some clarification on that question. Can you repeat it?
So if employer suggested or required all employees to get tested once one employee disclosed a positive test, the testing occurred on a holiday, does employer over double pay? Can it add substitute vacation days? What are employers' options? Assume A, employee volunteered, or B, assumed employees felt they were obligated.
So this sounds like it's a pretty specific question, and it might be something that this person might want to reach out to me directly about, because it sounds like there's some wage and hour questions involved, as well as testing questions, and I think that it's going to be a complicated answer for you. I'm sorry that I can't answer it necessarily right here on the spot, but if you do want to reach out to me directly, I'd be happy to look into that for you.
He mentioned in the chat box you'll reach out, so you'll be hearing.
Okay, great.
Another question is, many colleagues are requiring students to quarantine prior to going to school. Would that be a qualified event for an employee to quarantine?
for students who are going back to school?
So many colleagues are requiring students to quarantine prior to going to, yeah.
Okay, so if a college is requiring the quarantine, no. If the state or the local government is requiring the quarantine, or a healthcare provider is requiring the quarantine, then yes, it will be a covered event under FFCRA. But if it's just the college that is requiring the quarantine, then no, that is not an event that would require you to pay that paid leave for the 2 weeks. Because that they don't qualify as a government entity or a healthcare provider that is requiring the quarantine.
Perfect. All right, any other last minute questions? I don't see any coming through. So thank you, Rebecca, this morning for taking your time and for answering all these questions. Everybody, please feel free to reach out to her if you have any follow-up questions. Thanks for joining us, everyone. Please check our website if you have any questions, or let me know if the Kennebec Valley Chamber can do anything for you during this time. Thank you again to our sponsor, CMP, and I hope you guys all have a great day. Thanks.
Thank you. Bye-bye.
Bye-bye.